year is 1865. The Civil War is over. The Confederacy lost. And on December 6th, the United States of America ratified the 13th Amendment to the Constitution. Neither slavery nor involuntary servitude shall exist within the United States. Done. Finished. Slavery was officially, legally, permanently abolished. 4 million people who had been bought, sold, worked, beaten, and bred like livestock for 246 years were now free. The country celebrated. Newspapers ran headlines about a new dawn. Politicians gave speeches about liberty and justice. Former slaves wept in the streets, held their children, and prayed. And for about 5 minutes, it looked like the story was over. It wasn't. Because what happened next was, and I genuinely need you to hear this, somehow worse. Not things were tough for a while. Worse. Not there was some discrimination. Worse. They literally rebuilt slavery. From scratch. 3 times. And every single version was completely, entirely, 100% legal. This is the part of American history that doesn't make it into most textbooks. Not because it's hidden, not because the evidence is gone, but because it's embarrassing. So let's talk about it. Before we get to the 3 new versions, we need to talk about one sentence. 20 words that changed everything. Or more accurately, changed nothing. Here's the 13th Amendment again. But this time, read it slowly. Neither slavery nor involuntary servitude, except as a punishment for crime, shall exist within the United States. Except as a punishment for crime. 7 words. Buried in the middle of the amendment, like someone hoping no one would check the fine print. Most people, then and now, read the 13th Amendment and think slavery is abolished. Full stop. End of story. Let's go home. But there's no full stop. There's an asterisk. And the asterisk says, unless you're a criminal. Now, the former Confederate states, the ones who had just spent 4 years and 600,000 lives trying to keep slavery, they read those 7 words very carefully. Because the South had just lost everything. Their economy was in ruins. Their cities were burned. And now, on top of all of that, they'd lost their labor force. 4 million people who used to work for free, now expected to be paid. The plantation owners looked at their empty fields, looked at their bank accounts, looked at those 7 words, and collectively went, okay, we can work with this. And what they came up with next would make even the most creative lawyer raise an eyebrow. 3 versions, each one worse than the last. Let's start with the obvious one. The ink on the 13th Amendment wasn't even dry. Less than a month after ratification, Mississippi became the first state to pass what became known as the Black Codes, and the rest of the South followed within weeks. Now you'd think they'd at least try to be subtle about it. You'd think they'd maybe wait a few months, maybe ease into it. They did not. The Black Codes were printed in newspapers, debated in legislatures, and signed by governors. In broad daylight, with zero shame. Here's the highlight reel. The vagrancy law. If you were a black person without a signed labor contract with a white employer, you were a vagrant. Vagrancy was a crime, and the punishment was forced labor. If you were free, but didn't have a job, that was a crime. And the punishment for that crime was work. You see what they did there? Beautiful. Horrible. But beautiful. And the labor contracts were something else entirely. A black worker had to sign a 1-year agreement, usually with the same person who had owned them 6 months earlier. Same fields, same cabin, same overseer standing in the same spot with the same attitude. Quit before the year is up? Crime. Show up late? Crime. Talk back? Crime. Leave the property without a written note? Believe it or not, also crime. The punishment for all of these, you guessed it, more work. So here were the options for a newly freed black person in Mississippi in late 1865. Option A, Work for your former master under a contract you can't read, can't negotiate, and can't quit. Option B, get arrested for not working, and then be forced to work. That's the complete list. Those are all the options. South Carolina added a fun twist. Black people needed a special license to do any job besides farming or domestic service. The license? $10 to $100. How much money did most formerly enslaved people have? $0. Cool system, so you're free. But you can only do 2 jobs. And the other jobs require money you don't have. And if you don't work, you're a criminal. And criminals do. Free labor. It was slavery, in a trench coat, pretending to be something else. Louisiana went even further. They passed an apprenticeship law that let courts take black children away from their parents and assign them to white guardians, who could use their labor until age 18. That's not an apprenticeship. That's child slavery with a different font. Now here's the thing about the black codes. They were so obviously just slavery with new branding that even the federal government, which, let's be honest, was not exactly setting speed records on racial justice, looked at them and went, "Guys, come on." Congress passed the Civil Rights Act of 1866 and the 14th Amendment specifically to override the black codes. Federal troops were sent south to enforce the new laws. The black codes were officially shut down. Problem solved. Just kidding. Because the South looked at version 1. 0 getting rejected and thought, okay, we were too obvious. We need to be smarter. And smarter they got. Version 2.0 lasted not 1 year, not 10 years, 70 years. All legal. If the black codes were a blunt instrument, convict leasing was a surgical operation. 5 simple steps. Perfectly legal. Absolutely devastating. Here's how it worked. Follow along because the logic is almost impressive. Step 1. The 13th Amendment says slavery is illegal, except as punishment for crime. Step 2. Make everything a crime. Step 3. Arrest people. Step 4. Lease the prisoners to private companies. Step 5. Profit. That's it. That's the whole system. 5 steps from freedom to forced labor. All of it constitutional, and it ran from the 1870s to the 1940s. The 1940s, as in World War II was happening. America was fighting fascism in Europe and writing speeches about freedom and human dignity while leasing human beings to coal mines in Alabama. But I'm getting ahead of myself. Let's see how it actually played out. Meet James, a formerly enslaved man walking down a road in Georgia in 1878. He's not doing anything wrong. He's not hurting anyone. He's walking. A sheriff rides up. "Hey, where you going?" James. "Home." "You got a labor contract?" James. "No." "Vagrancy. You're under arrest." And just like that, James goes from free man to prisoner. The trial takes about as long as a lunch break, sometimes less. Due process? In a courthouse where the judge and the sheriff play cards together on Sundays? Sure. Due process. James is sentenced to 6 months of hard labor. But here's where it gets creative. The state doesn't want to pay to keep prisoners. Cells cost money. Guards cost money. Food costs money. So the state makes a deal. They lease James to a private company. A mine, a railroad, a turpentine camp. The company pays the state a few dollars a month. The state keeps the money. James works for free. Everyone wins. Except James. And here, right here, is where convict leasing became worse than slavery. Not as a figure of speech. Mathematically worse. Under slavery, a slaveholder had paid for an enslaved person. Hundreds, sometimes thousands of dollars. That person was an investment. A terrible, inhumane investment. But an investment. You don't let your investment die. You feed them. You house them. You need them productive. Under convict leasing, the company rented the worker for a few dollars a month. If that worker died, they'd rent another one. Zero investment. Zero incentive to keep anyone alive. The death rates tell the story better than I can. In some Alabama mining operations, 1 in 3 convict laborers died. 1 in 3. The conditions underground were exactly as bad as you're imagining right now, and possibly worse. And the crimes these people were arrested for? Here's a partial list. Vagrancy, walking without a destination, loitering, standing without one, insulting gestures, mischief, the law didn't specify what kind, changing employers without permission, and my personal favorite, selling cotton after sunset. Selling cotton after sunset. That was a crime. These weren't laws. They were shopping lists. When a coal mine needed more workers, the arrest numbers went up. When a railroad needed a crew, the sheriff suddenly got very busy. In 1898, convict leasing generated 73% of Alabama's entire state budget. 73%. The state was literally running on forced labor. Now people tried to stop it. Journalists wrote about it. Reformers campaigned against it. Frederick Douglass condemned it. But here's the thing about profitable systems. They don't stop because someone writes an angry article. Alabama, the last holdout, and honestly the most committed participant, officially ended convict leasing in 1928. Though similar arrangements continued quietly well into the 1940s. So to recap version 2.0, they took that loophole in the 13th Amendment, built an entire economy inside it, worked thousands of people to death, and made it last 70 years. All completely, perfectly, 100% legal. But surely, that was as bad as it could get. It was not. If convict leasing was slavery with a prison sentence, sharecropping was slavery with a spreadsheet, and it might have been the most effective version of all. Not the most violent, not the most dramatic, but the longest lasting. And sometimes, the quiet ones are the worst. It ran from 1865 to the 1960s. Almost 100 years. 3 full generations of families born, raised, and buried in a system that called itself freedom and functioned as a trap. Here's the setup. The war ends. 4 million newly freed people need everything. Land, food, tools, seeds, housing, money. They have none of it. They've spent their entire lives working for someone else. They own nothing. Now who has all of those things? Their former owners. And the former owners had a problem too. Thousands of acres and nobody to work them, so they made an offer. And I want you to notice how reasonable this sounds at first. I'll give you a piece of land, seeds, tools, a cabin. You farm it, and at the end of the harvest, you give me a share. The rest is yours. Sounds almost fair, right? Almost like a partnership. Here's what actually happened. The landowner's share was 50 to 70%, sometimes more. You worked dawn to dusk 6 days a week in the same fields you worked as a slave, and you kept whatever scraps were left, but that was just Act 1. Because during the year, you needed things: food, clothing, medicine, seeds for next season. And since you had no money, all your earnings went to the share. You bought everything on credit, from the landowner's store, at the landowner's prices, at the landowner's interest rates. Fun. By harvest time, the math looked like this. You grew $200 worth of cotton. Good year. Hard work. Landowner takes 60%. $120. You have 80, but you owe $95 to the store. Food, clothes, the tools you borrowed. Congratulations. You're now $15 in debt, and here's the rule that made the whole machine run. You cannot leave until your debt is paid. But the debt doesn't get paid, because next year the interest grows. Now you owe 30, then 50, then 100. Some families stayed in this cycle for generations. The same family, same land, same cabin, same landlord. For 60, 70, 80 years after they were freed. If that sounds like slavery with extra steps, that's because it was slavery with extra steps. The sharecropper couldn't read the contract because teaching slaves to read had been illegal, and nobody built schools after. The sharecropper couldn't challenge the math because the landowner kept the books. The sharecropper couldn't go to court because the judge lived next door to the landowner. The sharecropper couldn't leave because they were in debt. This wasn't a bug in the system. It was the system. Here's the final comparison. In 1870, the average sharecropper in Mississippi worked 10 to 12 hours a day, 6 days a week, and ended the year further in debt than they started. Under slavery, they worked 10 to 12 hours a day, 6 days a week, and earned nothing. Spot the difference. There isn't one. Except under sharecropping, the landowner didn't even have to feed them. It was an upgrade. For the landowner, all legal, so let's line them up side by side. Version 1.0. Black codes. You're free, but if you don't work for us, it's a crime. Lasted about 1 year. Too obvious. Federal government shut it down. Version 2.0. Convict Leasing. You're free, but we'll arrest you for walking and lease you to a mine. Lasted 70 years. The death rates got too high to ignore. The last states ended it in the 1920s and 30s. Version 3.0. Sharecropping. You're free. Sign this contract. Don't worry about the fine print. Lasted almost 100 years. It didn't end because of a law or a movement. It ended because millions of black Americans simply left. Between 1910 and 1970, 6 million people moved from the rural South to cities in the North and West. They didn't beat the system. They walked away from it. 3 different versions. 3 different methods. Same result. Black people working without real pay. Unable to leave. Unable to appeal. Under the full protection of American law. And the pattern, the one that should follow you after you close this video. Each version was built because the last one got caught. When the black codes were too blunt, they invented convict leasing. When convict leasing got too bloody, they leaned harder on sharecropping. Each new version was quieter, cleaner, harder to point at and call what it was. The system didn't evolve by accident. It evolved by design. And every single version hid behind the same 6 words. It's not slavery. It's the law. The 13th Amendment abolished slavery on December 6, 1865. That is a fact. It is written in the Constitution. But the men who slipped in those 7 words, except as a punishment for crime, knew exactly what they were building. And the men who used that exception for the next 100 years knew exactly what they were protecting. Slavery didn't end in 1865. It was rebranded 3 times. All legal, all worse.